All right, welcome back to Ace Your RES exam. Today we're strapping in for a deep dive into the Law Society of Singapore's Conditions of Sale 2020.
Important stuff.
Absolutely. Now, if you're staring down the barrel of the Singapore real estate salesperson exam, and let's face it, who isn't feeling a little bit nervous?
It's definitely a hurdle.
Right. This is the kind of knowledge that separates the pros from the please just let me pass crowd.
It really is. Understanding the framework.
Think of this as your, like, cheat sheet to understanding the legal lowdown, you know, without needing a law degree or a lifetime supply of coffee.
Exactly. We'll break it down.
Our mission, to dissect these conditions, pinpoint the exam gold, and leave you feeling like you've just unlocked a secret level in your RES prep.
Focused on what matters for the exam.
No more drowning in details. We're locked on to what'll actually get you across that finish line. So, ready to get started.
Let's do it. You know, when you first see the conditions of sale, it can feel a bit like deciphering ancient runes.
Totally. Looks intimidating.
But if we tackle it piece by piece, focusing on what's truly crucial for your RES exam, it starts to make sense. Definitions are key.
Okay, let's get our definitional ducks in a row then. First up, business day. It's not just any old day, is it?
Precisely. A business day has a very specific meaning here. It excludes Saturdays, Sundays, and importantly, all public holidays.
Ah, okay. Crucial for deadlines.
Super important for timelines in any property deal. For example, if your scheduled completion date lands on, say, a Saturday, it automatically bumps to the next business day. So yeah, no weekend completions legally required by that date.
Got it. So if your completion is set for a Sunday, you can actually relax, have your copy. That's good to know. Next, the CVY account. Sounds a bit formal.
It is, yeah. CVY account is short for conveyancing account. Conveyancing and law of property rules from 2011 define it.
And its role.
Basically, it's the designated pit stop for the purchaser's money when it's going to the vendor solicitor. Keeps things clear.
Like a safe holding zone for the cash.
Sort of. And here's a little tip for your exam. Even if the money accidentally ends up in another account belonging to the vendor's solicitor.
Wow.
Well, Condition 2.2 says it's generally still considered a valid payment. Think of it as a slight detour, but it's still got there.
Okay, good to know. There's a little wiggle room, not an instant fail if there's a small mix-up. Now, completion and completion date. Seems obvious, but any traps?
There could be. Completion is the act itself, the grand finale, the sale becoming official.
The actual handover moment.
Exactly. The completion date is just the specific day that finale takes place. So one's the action, the other's the date.
Right, the event versus the when. Got it. Contract. That's the agreement, right? Simple.
Well, the definition here is pretty broad, actually. It covers your standard private deals, sure, but also sales from auctions or tenders.
Okay, different ways of selling.
And crucially, it also includes options that have been exercised. So once that option is triggered, boom, it's officially a contract under these conditions.
So that initial option to purchase basically transforms into the main contract once exercised.
Okay.
And property itself, what exactly does that cover? The whole shebang.
Legally speaking, under these conditions and the relevant acts like the Conveyancing and Law of Property Act, property specifically means land.
Just the land.
That's the legal core of it, yes. So for your exam, remember the focus is on the land.
Land is the key. Makes sense. Now, scheduled completion date versus just completion date, is that just being fancy?
Not at all. There's a difference. The scheduled completion date is the date originally agreed in the contract.
The target date.
Exactly. But, as we mentioned with business day, if that date falls on a non-business day, the actual completion date slides to the next business day.
Ah, so scheduled is the plan, completion date is the reality if a weekend interferes.
You got it. Scheduled is the intent. Completion date is when it actually happens.
Okay. Finally, for this round, SSD. We hear that acronym a lot.
SSD is seller's stamp duty. It's a tax the seller might have to pay under the Stamp Duties Act.
When does it apply?
If they sell their property within a certain time frame after buying it.
Yeah.
Definitely a term you need to know.
Right, a cost the seller needs to be aware of, and agents too. Okay, let's move on to money matters. Condition 2, the CVY account again. Anything else there?
Condition 2 is fairly straightforward, like we touched on. Payments should go to the vendor's solicitor's CVY account. But Condition 2.2 clarifies that if it lands in another of the solicitor's accounts, the payment is still technically valid. It avoids unnecessary panic.
Good fallback. Now, what if a payment just fails? Bounces. Condition 4, dishonored payment. Sounds like trouble.
It is, potentially. If a payment like a check bounces, The vendor has a choice. Two main options.
Which are?
They can treat the contract as repudiated, basically say this deal is off, and walk away.
Option 1, cancel.
Or they can choose to affirm the contract, keep it alive, and demand the payment be made good immediately.
Option 2, demand the cash. So the vendor decides. Now, delays, late completion interest under Condition 9. That sounds expensive.
It can be. Condition 9 spells out the interest charges if completion is late because one party defaulted.
Either the buyer or the seller being slow.
Exactly. Whether it's the purchaser delaying payment or the vendor unable to hand over the property on time, the party at fault generally pays interest.
And the rate?
It's set at 8% per annum, calculated on the purchase price, though there are some specific calculations for subsales.
8%, okay. Need to remember that. When does it start ticking?
The day after the scheduled completion date, and it stops when completion actually happens.
Ouch. Are there ways out? Situations where you don't pay this interest?
Yes, thankfully. Conditions 9.4 through 9.7 list several key exceptions.
Like what?
Well, no interest is charged if the delay is due to something completely beyond either party's control, or if, maybe, both are equally to blame.
Acts of God, maybe. Or mutual delays.
Something like that.
Oh.
Also, if, sadly, the vendor or purchaser passes away or loses mental capacity before the scheduled completion date, there's a grace period.
How long?
Up to 3 months delay is allowed without interest kicking in.
That makes sense. Accommodates real life. What else?
Okay, this is important for purchasers. No interest is payable if the vendor is late providing their payment details. They need to give at least 7 clear business days notice before the scheduled completion date.
So if the vendor delays telling you where to pay...
Then the interest clock doesn't start for the number of days they were late giving that info.
Fair enough. Anything else?
One more big one. If the STARS e-lodgement system, that's the electronic system for property deals, has a major outage.
Like a system crash.
Yeah, if it's down for more than 4 hours and requires manual processing, then no late completion interest is charged for the days affected by that downtime.
Okay, those exceptions 9.4 to 9.7 definitely exam-worthy detail. Got it. Now let's shift focus to the actual property. Condition 5. State and condition on delivery. What's the rule here?
Condition 5.1 is key. It says the vendor must hand over the property in the same state and condition it was in on the date the option was granted, or the contract date, whichever came first.
Same condition, but what about, like, normal use?
Exactly. It excludes fair wear and tear. So minor scuffs from living there are okay. Finding a massive new hole in the wall, not okay.
Right, and vacant possession.
Ah, yes. Condition 5.2. If the deal includes vacant possession, the vendor has to clear out all their stuff, furniture, personal belongings by completion. No leaving junk behind.
Haha, good. No inheriting Uncle Bob's armchair unless you agreed to. What about ongoing costs? Condition 6, outgoings, rents, and profits until completion. Who pays the bills?
Generally under 6.1, the vendor gets any rent or profits from the property and pays for all the expenses, outgoings, levies, up to and including the scheduled completion date.
Okay, vendor's responsibility up to the target date.
Then under 6.2, the purchaser takes over. They pay the bills from the day after the scheduled completion date and get any rent or profits from then on.
Makes sense. What about specific levies, like for condo upgrades?
Condition 6.3 covers that. If there are levies for improvements to common property, the vendor pays any lump sum or installment that's due on or before the scheduled completion date.
Got it. And there's an interesting option for the vendor if the buyer delays.
Yes, condition 6.4. If the purchaser delays completion, the vendor can choose to waive the late completion interest.
Oh, why would they do that?
But instead, they get to keep any rents from the property and just cover the outgoings themselves until the actual completion date happens. It gives them a choice depending on the situation.
Interesting tactical choice. Okay. Condition 8, state of property as to repair. Sounds like buyer beware.
It leans that way, yes. Subject to what's promised in Condition 5, same condition, and Condition 10, warranties. Condition 8 basically says the purchaser is deemed to have accepted the property's physical state.
Whether they checked properly or not.
Pretty much. Things like access, the state of repair, light, drainage, the buyer is assumed to know or have checked. It really highlights why inspections are so important.
Absolutely. Get that inspection done. Now, speaking of promises, Condition 10, vendor's representation and warranties. What does the seller guarantee?
Condition 10 gives some key assurances. Under 10.1, the vendor promises they haven't done any unauthorized additions or alterations. No illegal extensions, basically.
Okay, important for compliance. What's 10.2 about?
Condition 10.2 deals with past transactions, especially if the property was sold or transferred at a low value or even gifted before this sale.
Why does that matter?
It relates to the Insolvency, Restructuring, and Dissolution Act. The vendor warrants that enough time has passed since that low-value transaction to protect the new purchaser from claws back if the vendor later faces bankruptcy or insolvency issues. It's a protection against potentially dodgy past deals.
Ah, right. Protecting the buyer from the seller's potential financial skeletons. Makes sense. Now, taxes. The fun part. Condition 7. Everyone wants a piece.
Haha, it can feel like that.
Mm-hmm.
Condition 7 lays out who pays what. Property tax, that's 7.1. Vendor pays up to the scheduled completion date.
Even if the bill isn't out yet?
Yeah, they might need to make an allowance or hold money back with lawyers if the final assessment isn't available.
Okay.
Goods and services tax, 7.2. That generally falls on the purchaser if GST is applicable to that specific sale. Not all residential sales attract GST.
Right, depends on the vendor status. What about withholding tax, 7.3?
That applies if the vendor is considered a non-resident for tax purposes and makes a taxable profit. The purchaser might be required to deduct a portion of the price and pay it directly to IRA as withholding tax.
So the buyer acts like a temporary tax collector.
In a way, yes. And the vendor has to inform the purchaser if this applies. Otherwise, the vendor might have to cover the purchaser if they get penalized.
Okay, complex but important. And we met seller's stamp duty, SSD, earlier. What does 7.4 add?
Condition 7.4 says the vendor must tell the purchaser the SSD amount payable and show proof they've paid it.
And if they don't pay?
But then the purchaser has the option, not an obligation, but an option, to deduct that SSD amount from the purchase price and pay it directly to the tax authority, just to make sure it gets paid.
A safety net for the buyer. And buyer's stamp duty, BSD, 7.5.
That one's straightforward, purchaser's responsibility to pay. They also need to provide proof of payment to the vendor if asked.
Natural. And the non-merger clause, 7.6.
That just means all these tax obligations in 7.1 to 7.5 don't just vanish once the sale is completed. They survive the conveyance and remain enforceable.
Got it. Tax duties stick around. Okay, paperwork time. Condition 3, documents of title. Who needs to show what and when?
The vendor has to get the original title documents, or certified copies, ready for the purchaser to inspect at least 1 month before the scheduled completion date.
And the buyer has to look.
Well, technically, whether the purchaser actually inspects them or not, they're legally considered to know what's in them. So, best to look.
Good advice. Can the buyer's lawyer borrow the originals?
Usually, yes. The vendor typically lends the originals to the purchaser's solicitor against a formal promise, an undertaking, to return them safely.
And costs, if the docs are with the bank.
The vendor bears the cost of getting any documents from their mortgagee, yeah.
Fair enough. Now, the main event, document the conveyance under Condition 14. Who prepares that?
The purchaser prepares the conveyance document, and they pay for preparing it.
Okay, buyer drafts it. What does the vendor do?
The vendor's job is to execute it, sign it, once the balance payment comes in. And critically, the vendor must arrange for any existing mortgages or charges on the property to be released so the purchaser gets a clean title.
So, vendor clears the debts, buyer prepares the transfer doc.
Exactly. And each party pays their own lawyer's costs for reviewing and signing their respective parts.
Makes sense. Now, what happens when things get delayed? We talked interest, but what about the formal step, notice to complete, Condition 15?
Right. The notice to complete is a formal mechanism used when time wasn't strictly of the essence in the original contract.
So if the scheduled date passes without completion?
Either party can serve this written notice on the other party to force the issue. But there's a condition for the vendor. The vendor has to wait at least 5 clear business days after they've given the purchaser the payment instructions before they can serve the notice.
Okay. Give the buyer time after telling them where to pay, and the party serving the notice.
They must be ready, able, and willing to complete the transaction themselves when they serve it. You can't demand completion if you're not ready yourself.
Fair point. And once served, what happens?
Once a valid notice to complete is served, it sets a hard deadline. The other party has 21 days to complete the sale. And at this point, time does become strictly of the essence.
Okay, so it's a 21-day countdown. Serious stuff. What if the purchaser still doesn't complete after receiving the notice from the vendor?
Then the vendor has some pretty strong remedies under Condition 15. They can forfeit the deposit.
Keep it.
Keep the deposit,
Yes.
And they can resell the property, either privately or by auction. And if they suffer a loss on the resale,
They can sue the original buyer?
they can sue the original defaulting purchaser for damages, like the difference in price or extra costs incurred.
Ouch. Serious consequences. What if it's the other way around? The vendor defaults after the purchaser serves the notice.
The purchaser also has options. They can go to court and ask for specific performance, basically, in order forcing the vendor to complete the sale.
Force the sale.
Yes,
Yeah.
or alternatively, the purchaser can demand immediate return of their deposit and any other money paid, plus interest, and they can still sue the vendor for damages caused by the breach.
So, powerful tool for both sides. Now, disagreements. Condition 16 mentions mediation. Is it compulsory?
It's encouraged, strongly encouraged. Condition 16 points towards using the Law Society mediation rules first.
It's not required.
Correct. It explicitly states neither party is legally obligated to mediate before starting arbitration or going to court. It's a suggestion for a potentially cheaper, faster resolution.
Let's try talking first clause. Sensible. Condition 17. Special conditions. What are these?
These are just any extra conditions that the buyer and seller specifically agree to add to their contract, beyond the standard Law Society ones.
And if they clash with the standard ones?
Condition 17 is clear. The special conditions always win. They override the standard conditions if there's a conflict. Custom clauses take precedence.
Got it. Tailored terms rule. Okay, nearly there. Condition 13. Passing of risk. Who carries the risk if something happens to the property before completion? Like a fire or that falling durian?
Huh? Yes. Condition 13 actually disapplies a specific section of the Conveyancing and Law of Property Act.
So what's the rule under these conditions?
The rule here is that the risk stays with the vendor. It only passes to the purchaser upon actual completion or when the purchaser takes possession of the property, whichever happens earlier.
So until completion or handover, if the durian strikes, it's the vendor's problem.
Generally, yes. The vendor bears the risk until the very end.
Good to know for the buyer. Condition 11. Misdescription of property. What if the details aren't quite right?
Condition 11 says the property is sold subject to existing things like tenancies, rights of way, etc., and for minor errors or inaccuracies in the contract description.
Like a slight measurement mistake.
Exactly. If it's minor and doesn't significantly affect the property's value, neither party can back out or claim compensation. It's considered immaterial.
But major errors would be different.
Oh, yes. A significant material misdescription could potentially allow the buyer to rescind or claim damages.
Okay, last one. Condition 12. Demands of local or statutory authorities. Notices from the government.
Right. If any government body, or maybe the condo management or the lessor, issues a notice requiring work or changes to the property before the scheduled completion date.
Who handles it?
Condition 12 puts the responsibility squarely on the vendor to comply with those notices. If they haven't done it by completion, they usually need to compensate the purchaser or set aside funds to cover the cost.
Vendor has to sort out official demands made before the target date. Got it. Phew. All right, we've covered a huge amount of ground today on ACE Your RES exam. I mean, from definitions to delays, taxes to title docs.
Yeah.
We've really dug into these Law Society conditions of sale 2020.
We certainly have. And it's clear, isn't it, how understanding these is just fundamental for the exam.
Absolutely essential, not just for passing RES, but, for actually being a competent, knowledgeable real estate professional out there.
Exactly. This forms the backbone of so many transactions. Knowing this stuff gives you confidence, helps you guide clients properly. It's practical knowledge.
Totally. So to all you amazing future RES superstars listening, remember to go back over these key areas. Nail those definitions: business day, completion date, CVY account.
Understand the money flow, the interest rules, those exceptions under Condition 9.
Know who's responsible for the property's condition, the taxes, SSD, BSD, property tax, and the documents.
And be clear on the notice to complete process and what happens if things go wrong.
You've absolutely got this. And from both of us here at ACE Your RES exam, we wish you the very, very best of luck in your upcoming RES exam. Go out there and smash it.
Good luck, everyone.
Now, just a little something to mull over as you hit the books. Imagine a situation where a major, unexpected government policy change is announced after the option is granted but before completion. Let's say it significantly hits property values in that specific area. How do you think the existing conditions of sale might or might not address something like that? Something unforeseen hitting the deal midway. Just a little food for thought for your brilliant exam-ready brains.